facing the police every single day.
In the County Court of the 20th Judicial Circuit in N. For Lee County, Florida, Criminal Division. State of Florida. Case number, 21MO020115. V.S. Michael Angelo Ponzano, Defendant. Motion to dismiss. Comes not Defendant, Michael Ponzano, and respectfully requests this court to dismiss the citations in this case and declare Article V of the Fort Myers Municipal Code unconstitutional. In support of the motion, the defendant asserts the following. On March 28, 2021, Michael Ponzano was preaching within public areas of the city of Fort Myers, exercising his cherished rights of freedom of speech and religion, when he was issued citations for alleged violations of Fort Myers Noise Ordinance, Article V, 54. 197, A. The essential noise regulations of the City of Fort Myers are found in Article V of its Municipal Code. Article V is divided into 4 sections, 54-196, 54-197, 57-198 and 54-199. The first section, 54 to 196, consists of an introductory paragraph and 13 subsections. The introductory paragraph sets forth the apparent purpose of Article V as the prevention of loud, disturbing, and unnecessary noise. The second section of Article V, 54 to 197, is titled Conveyances, Locomotives. Michael Ponzano was cited under 54-197, A, of Article V. The section states it is unlawful for any pedestrian, or person operating or occupying any conveyance, aircraft, vehicle, vessel, motorcycle, or bicycle upon the streets, alleys, waterways, or other public places in the city to operate or amplify the sound produced by a radio, compact disc, or tape player, musical instrument, voice, or other machine or device for producing or reproducing sound in such a manner as to be audible at a distance of 25 feet or more from the source of the sound. The term pedestrian is not defined anywhere within the Fort Myers Municipal Code. Emphasis added. The third section, 54-198, is titled Radio, Television, and Other Electronic Device Sound Levels, Violations. The focus of this section is the use of electronic devices. This section specifies allowable decibel levels for electronically generated sound based on location and time of day. The last section, 54 to 199, contains exceptions and waivers for noise that may otherwise be outlawed in other sections. At the times he was cited, Mr. Ponzano was exercising his free speech rights in a public forum. He was not in a vehicle, or a locomotive, and he was not traveling by foot. He was standing and exercising his free speech rights in a traditional public forum. Filing #130418970 filed July 12, 2021, 9:10 and 45 seconds a.m. E-filed Lee County Clerk of Courts, page 1. The defendant requests this honorable court for an adjudication of not guilty, a dismissal of all charges, and a determination that Fort Myers Municipal Article V is both unconstitutionally overboard and unconstitutionally vague. 1. Michael Ponzano did not violate Fort Myers Ordinance 57.197 and the case should be dismissed as a matter of law. Mr. Ponzano was given cited for an alleged violation of Article V, Fort Myers Noise Ordinance. The defendant contends that at the time he was cited he was not a pedestrian within any appropriate construction or usage of the term pedestrian. The Florida Supreme Court, in State v. Weeks, 202 So. 3D1, FLA 2016, outlined Cor. Tenets of statutory construction. The court said, he is starting point of our statutory construction analysis is a search of the text of the statute for plain meaning. In ascertaining the plain meaning of statutory language, consulting dictionary definitions is appropriate. ID at 7. The court explained the importance of context in statutory construction as the doctrine nocitur associus, explaining that a word is known by the company it keeps. ID. Moreover, the court identified the rule of lenity is a fundamental tenet of Florida law regarding the construction of criminal statutes, which weighs in favor of the defendant. ID at 8. Application. These basic rules of statutory construction demonstrate that Mr. Ponzano was not a pedestrian within the meaning of 54.197a, and that he should not have been cited under that section. That section states: a. Section 54 to 197. Conveyances, locomotives. It is unlawful for any pedestrian, or person operating or occupying any conveyance, aircraft, vehicle, vessel, motorcycle, or bicycle upon the streets, alleys, waterways, or other public places in the city to operate or amplify the sound produced by a radio, compact disc, or tape player, musical instrument, voice, or other machine or device for producing or reproducing sound in such a manner as to be audible at a distance of 25 feet or more from the source of the sound. Emphasis added. The plain and common meaning of pedestrian is one who travels on foot. Merriam-Webster's dictionary defines pedestrian as a person going on foot, walker. The context of the term pedestrian is that of a person traveling according the heading conveyances, locomotives, and according the companion travel words conveyance, aircraft, vehicle, vessel, motorcycle, or bicycle. The rule of leniency is another rule of statutory interpretation. The rule of leniency is summarized as a New York ambiguity or situations in which statutory language is susceptible to differing constructions must be resolved in favor of the person charged with an offense. State v. Byers, 823 So.2d 740, 742, FLA 2002. The rule of leniency prohibits the term pedestrian from being broadly taken and synonymous with people in general. E. filed Lee County Clerk of Courts, page 2. Mr. Ponzano should not have been charged under Section 54-197, a. There are other sections within the ordinance that were readily associated with Mr. Ponzano's activities when he was cited. See Municipal Ordinance Article V, 54.196, 2, 54.196, 4, and 54.198. Unlike Section 54 to 197, these sections are not directed to vehicles, locomotives, or pedestrians. These sections apply to people in general and would be applicable to Mr. Ponzano. However, there is no evidence that Mr. Ponzano was in violation of these sections and he was not cited under those sections. Section 54.196, 2, requires the noise to be disturbing outside 50-foot perimeter, and it is only applicable between late night hours, 10:30 p.m. to 7 a.m. Section 54.196, 4, also requires the noise to be disturbing, and it is also limited 10:30 p.m. to 7 a.m. Section 54.198 requires decibel measurements. No decibel measurements were taken. The misapplied law, Section 54-197, does not require the noise to be disturbing and is not limited by any time parameters. The officer's selective, misplaced use of the harshest among all possible ordinances violates the rule of leniency. Mr. Ponzano respectfully requests this court to construe the ordinance according to sound legal principles and find that he has not violated Fort Myers noise ordinance and determine the ordinance is unconstitutional as set forth in sections 2 and 3 of this motion. To dismiss. 2. Fort Myers noise ordinance, Article V, outlaws a substantial amount of protected speech and broadly infringing upon fundamental rights and is unconstitutional as overbroad. An ordinance that outlaws constitutionally protected activities along with unprotected activities and sweeps too broadly infringing the upon fundamental right of expression is properly categorized as overbroad. In State v. Catalano, 104 so. 3D 1069, 1079, FLA. 2012, the Florida Supreme Court said, the overbreadth doctrine prohibits the government from banning unprotected speech if a substantial amount of protected speech is prohibited or chilled in the process. The government may regulate expression only with narrow specificity. ID at 1077. While the government may restrict such expression in a public forum, any limitations on the time, place, and manner of the protected speech must be reasonable. Any restriction must also be justified without reference to the content of the regulated speech and be narrowly tailored to serve a significant governmental interest. See Daly v. City of Sarasota, 752 So.2 D 124, FLA 2nd DCA 2000. The facts of this case are remarkably similar. A leading federal case where the court held that an ordinance that prohibited noise that could be heard at 25 feet was unconstitutional. In that case, Deegan v. City of Ithaca, 444 F.3 D 135, 2nd Sir 2006, the court said, to withstand constitutional scrutiny, government restrictions must be, 1. Content neutral, in that they target some quality other than substantive expression, 2. Narrowly tailored to serve a significant governmental interest, and 3. Permit alternative channels for expression. ID. This standard is commonly referred to as intermediate scrutiny. Deegan at 142. E. filed Lee County Clerk of Courts page 3. To withstand intermediate scrutiny in this case, the content-neutral means of furthering the city's interest in protecting its citizens from unreasonable noise must avoid unnecessary intrusion on Deegan's freedom of expression. See Ward at 788-89, 109 S.CT 2746. The narrowly tailored standard does not tolerate a time, place, or manner regulation that may burden substantially more speech than necessary to achieve its goal, nor does it require that the least restrictive alternative available be used. Deegan at 143. By targeting noise that is unreasonable, Ithaca's noise regulations evince an intent to reach noise that exceeds what is usual and customary in a particular setting. The stipulated facts reflect that in addition to being a commercial center, the Commons is used regularly for festivals, performing events, exhibitions, political demonstrations, and recreational activities. These are not quiet pursuits that require a quiet atmosphere. Emphasis added. Deegan at 143. Defendants interpret unreasonable noise as sound that can be heard 25 feet from its source. Construed in this broad manner, the regulatory proscriptions of the noise ordinance and the sound amplification rule embrace not only Deegan's protected speech, but the sounds that typify the Commons and the activities it is meant to facilitate. Emphasis added. Deegan at 143,144,144. Taking into account the nature and purposes of the Commons, along with its ambient characteristics, DO 968 F.2 D at 91, we hold that the City of Ithaca Municipal Code S 240-4 and 157-18, as interpreted and applied by defendants, unreasonably burden protected speech and therefore cannot withstand Deegan's constitutional challenge. Deegan at 144. The Florida Supreme Court in State v. Keaton explained overbreadth saying, overbroad statutes create the danger that a citizen will be punished as a criminal for exercising his right of free speech. If this possibility were the only evil of overbroad statutes, it might suffice to review convictions on a case-by-case basis. But the mere existence of statutes and ordinances purporting to criminalize protected expression operates as a deterrent to the exercise of the rights of free expression, and deters most effectively the prudent, the cautious and the circumspect, the very persons whose advice we seem generally to be most in need of. State v. Keaton, 371 So.2 D 86,92,93, FLA 1979. In State v. Catalano, 104 So. 3D 1069, FLA 2012, the Florida Supreme Court reviewed a statute to was similar the Fort Myers noise ordinance and held the statute was unconstitutionally overbroad. The case came about because of citations issued for violations of the noise control provisions FLASTAT 316.3045. The Florida Supreme Court held that the statute was unconstitutionally overbroad but not unconstitutionally vague. E-filed Lee County Clerk of Courts page 4. The statute in question made it unlawful for vehicle operators or occupants to amplify sound by mechanical means to the extent that the sound is plainly audible at 25 feet from the vehicle. The statute, however, exempted vehicles used for business or political purposes from the restrictions. This exclusion of business and political purpose vehicles resulted different legal standards despite essentially identical circumstances forming the focus of the court's constitutional analysis. The court said, regardless of the intent of the legislature, Section 316.3045 is a sweeping ban on amplified sound that can be heard beyond 25 feet of a motor vehicle, unless that sound comes from a business or political vehicle, which presumably uses sound-making devices for the purpose of expressing commercial and political viewpoints. For instance, business and political vehicles may amplify commercial or political speech at any volume, whereas an individual traversing the highways for pleasure would be issued a citation for listening to any type of sound, whether it is religious advocacy or music, too loudly. Emphasis. Added ID at 1079. Within the setting of the government's policy of traffic safety, for all practical purposes, regular vehicles were identical to vehicles used for political or business purposes. The court said, it is unclear how the statute advances those interests by allowing commercial and political speech at a volume plainly audible beyond 25 feet, but not allowing non-commercial speech to be heard at the same distance. C. Montgomery, 69 So.3d at 1032, we fail to see how the interests asserted by the state are better served by the statute's exemption for commercial and political speech. The state simply argues that non-commercial vehicles are more dangerous to the public because they are ubiquitous. This argument, however, fails to explain how a commercial or political vehicle amplifying commercial or political messages audible a mile away is less dangerous or more tolerable than a non-commercial vehicle amplifying a religious message audible just over 25 feet away from the vehicle. ID at 108. Emphasis added. The court's analysis boils down to a few simple steps. The court first identified two groups associated with the requirements the statute whose free speech rights would be affected in a vastly different manner by the statute. One group, the non-business and commercial vehicles, would have free speech rights curtailed, the other group would not. The court then identified the policy reason for the underlying statute and determined that the underlying policy did not justify curtailing the free expression to one group, operators and occupants of vehicles, while not limiting the free speech rights for the other group, operators and occupants of business and political vehicles. The method of analysis used by the Catalano court tests whether the policy provision is genuine or sufficient to justify breadth of the free speech limitations in the underlying regulation. The analysis, e-filed Lee County Clerk of Courts page 5, revealed the statute in Catalano was overbroad. The same analysis reveals that the noise ordinance in this case is unconstitutionally overboard. The use of the term pedestrian in 54-197, for the purpose of application of Article V of the Fort Myers Municipal Code for application purposes creates two groups of people: pedestrians and non-pedestrians. At any given moment on the streets, parks, or public areas of Fort Myers, both pedestrians and non-pedestrians will be present. For example, consider an art festival, a music where streets are blocked for traffic. Consider a public park or even people on sidewalks waiting outside of a restaurant for table service. The people attending events on blocked-off streets, people in public parks, or people waiting for table service are in the group non-pedestrians. People walking to their vehicles through a traffic-excluded area, people walking through a city park, or even people walking on a sidewalk past a group of people waiting for table service would be in the pedestrian group. Is there even any conceivable policy use the term pedestrian in 54-197, when it results in restricting the constitutional rights the pedestrians as shown by this example? Could the provision of 54-197, be worded in a way to accomplish its purpose, i.e., narrowly tailored, so that its purpose is accomplished without creating constitutional issues? It is hard to imagine what government policy could justify the unnecessary intrusion into constitutional rights. As to specific policies, would a focus on require the loose term pedestrian? How does limiting amplified sound on city center sidewalks, city parks, or cordoned-off events promote traffic safety? The overall policy underlying the noise ordinance seems to be implied from the introductory paragraph of section 54-196. The goal of Article 5 seems to be to noise control 54-197, the streets of Fort Myers are generally carrying a significant volume of ambient sound, and it would be surprising at most times to be able to find a quiet area 25 feet from any source of sound. In any event, how could the goal of reducing loud, disturbing and unnecessary sound be promoted by 54-197, There is no reason to suspect that pedestrians are noisier than non-pedestrians. Moreover, if the goal is the control of loud and disturbing sounds, 54-197, is unwarranted because its provisions do not require the sound to be loud or disturbing. Fort Myers Noise Ordinance Article V, and specifically Section 54-197, restricts more speech that necessary and must be held unconstitutional as overbroad. See also, Martin v. State, 259 So.3d 733, FLA 2018. 3. The Fort Myers Ordinance fails to give a person of common intelligence fair and adequate notice of the conduct prohibited, and therefore it is unconstitutionally vague. The application of the undefined term pedestrian of Section 54-197, and its overlap with 54-196, 2, 54-196, 4, and 54-198, renders Article V of the Fort Myers Municipal Code unconstitutionally vague. The term pedestrian is commonly used in conjunction with traffic. In common parlance, a pedestrian is someone crossing or walking on a roadway. The dictionary definition of pedestrian is a person going on foot. The term filed Lee County Clerk of Courts, page 6. Pedestrian, however, is not commonly understood to be synonymous with the term person, or one who conducting business or engaging in activities within a city. The constitutional issues associated vagueness is explained by the second DCA as follows. The vagueness doctrine was developed to ensure compliance with the Due Process Clause in the Fifth Amendment of the United States Constitution. Simmons v. State, 944 So.2 D 317, 324, FLA 2006. The Florida Constitution, 2, guarantees that no person shall be deprived of life, liberty, or property without due process of law. Art. I. 9, FLA. Const. The void for vagueness doctrine requires that a penal statute define the criminal offense with sufficient definiteness that ordinary people can understand what conduct is prohibited and in a manner that does not encourage arbitrary and discriminatory enforcement. Colander v. Lawson, 461 U.S. 352, 357, 103 S.CT 1855, 75 L.ed 2D 903, 1983. Void for vagueness simply means that criminal responsibility should not attach where one could not reasonably understand that his contemplated conduct is proscribed. United States v. National Dairy Prods Corp., 372 U.S. 29, 32-33, 83 S.CT 594, 9 L.ed 2D 561, 1963. Notice is the touchstone by which we evaluate a vagueness challenge. See Wish v. State, 619 So.2 D. 231, 236, FLA 1993, a statute or ordinance is void for vagueness when, because of its imprecision, it fails to give adequate notice of what conduct is prohibited. Thus, it invites arbitrary and discriminatory enforcement. The standard for testing vagueness under Florida law is whether the statute gives a person of ordinary intelligence fair notice of what constitutes forbidden conduct. State v. Crumbly, 247 So.3 D 666, 669. FLA 2nd 2018. Noise-related restrictions innately impact speech and carry the potential of exerting a chilling effect on free speech. The standard for review is therefore broad and abstract. In a recent case, State v. Catalano, 104 So. 3D 1069, FLA 2012, the Florida Supreme Court conducted a broad and abstract review of a noise-related statute brought as a collateral attack by two people who were cited for playing their car radios too loud. The breadth of the court's analysis illustrates the scope of the review required for noise-related measures. In Catalano, the court determined that the statute under review was not vague. However, the ordinance in this case and the statute in Catalano are quite different. The focus of the Catalano was on the enforcement term plainly audible. In this case, the focus is on the identity term, pedestrian, and on overlapping sections with differing enforcement standards. The Catalano statute involved operators and occupants of motor vehicles. The ordinance in this case throws pedestrians into the mix. Filed Lee County Clerk of Courts, page 7. Unlike Catalano, in this case there are several overlapping sections with contrasting Enforcement standards. For example, 54 to 196, 2, includes electronic devices that amplify sound but only restricts sound that disturb the peace, quiet, and comfort of neighboring inhabitants. Section 54-196, 4, is limits yelling and shouting to the hours of 10:30 p.m. and 7 a.m., or at any time or place so as to annoy or disturb the quiet, comfort, or repose of persons in any office, dwelling unit, or house of worship, or in the vicinity. These sections overlap Section 54-197, with its conflicting expansive enforcement. Standard of audible at 25 feet. There are no such sections in Catalano. Unlike Catalano, the Fort Myers Ordinance creates a trap for the unwary people presenting themselves in public areas of Fort Myers to convey a message, whether it takes the form of political protest, civic education, animal or environmental rights, or street preaching. Like Michael Ponzano would not think of themselves as pedestrians. The Florida Supreme Court in Wish v. State, 619 So.2 D 231, FLA 1993, explained. Vague laws offend several important values. First, because we assume that man is free to steer between lawful and unlawful conduct, we insist that laws give the person of ordinary intelligence a reasonable opportunity to know what is prohibited, so that he may act accordingly. Vague laws may trap the innocent by not providing fair warning. Second, if arbitrary and discriminatory enforcement is to be prevented, laws must provide explicit standards for those who apply them. A vague law impermissibly delegates basic policy matters to policemen, judges, and juries for resolution on an ad hoc and subjective basis, with the attendant dangers of arbitrary and discriminatory application. ID at 236,237. The term pedestrian and its potential to be applied defined as any person not in a vehicle. Along and the confusion associated with potential overlap from identifiers other sections creates a trap for the innocent and chills the free exercise of expression. Accordingly, this court should determine that Article V, Fort Myers Noise Ordinance is unconstitutionally vague. For Fort Myers Municipal Ordinance 54-197 as applied in this case violates Michael Ponzano's constitutional rights and the citation must be dismissed. Mr. Ponzano was charged with a noise violation merely because the officer could hear him at 25 feet. His message may have been disturbing to some people, but there was no showing or evidence that his sound level was unduly loud or disturbing. The officer should have used the standards of 54-196, 2, 54-196, 4, and 54-198A, to evaluate any complaints about Mr. Ponzano. Instead, the officer resorted to 54-197 even though it was inapplicable and devoid of objective standards. The Fort Myers Noise Ordinance was unfairly applied in a way that violate Mr. Ponzano's ability to exercise his constitutional rights. The citation must be dismissed because as applied 54-197 was used to violate the defendant's constitutional rights. E-filed Lee County Clerk of Courts page 8. 5. Michael Ponzano was subjected to selective enforcement in violation of his right to equal protection under the U.S. Constitution, and the charge must be dismissed. Michael Ponzano was singled out for special treatment that people and his constitutional rights were violated at the time or under similar circumstances for which Mr. Ponzano was cited. Others yell, play music and amplify sound in downtown Fort Myers with impunity. A party can assert a Class of 1 equal protection violation when he shows he has been intentionally treated differently from others similarly situated and that there is no rational basis for the difference in treatment. Village of Willowbrook. Violating, 528 US 562, 564, 2000, see also Campbell v Rainbow City, alyea. 434 F.3d 1306, 1314, 11th CIR 2006, recognizing class of 1 claims in the zoning context. To be similarly situated for purposes of a CLASS of 1 equal protection claim, a plaintiff must use comparators that are prima facie identical in all relevant respects. Campbell v Rainbow City, alyea, 434 F.3d. 1306, 1314, 11th CIR 2006. Accordingly, the citations must be dismissed. Submitted for filing and service to e-file portal this 12th day of July, 2021. Fairs M. Heindel, ESQ. Attorney for Defendant. Florida Bar Number 332437. PO Box 1009, Marco Island, Florida 34146. 239-285-5048. PMHEINDL@gmail.com.